Minnesota Real Estate Law Exam Questions. Question 1. Which fiduciary duty requires a broker to keep client money and property properly accounted for Finley and Stillwater involving a farm parcel priced at $214,500? Option A. Accounting. Option B. Assemblage. Option C. Accretion. Option D. Devolution. The correct answer is option A. Accounting. Accounting requires a broker to account for money and property received on behalf of a client. Assemblage, accretion, and avulsion are property or land concepts, not fiduciary duties. The key clue is handling client property and funds. Question 2. A salesperson discovers an error in an advertisement after publication. What is the most professional next step for Quinn in Duluth involving a vacant lot priced at $365,500? Option A. Ignore it because errors in ads never matter. Option B. Promptly correct the advertisement and notify the broker according to office procedures. Option C. Blame the buyer publicly. Option D. Delete all transaction records. The correct answer is option B. Promptly correct the advertisement and notify the broker according to office procedures. Advertising must be accurate and compliant, so prompt correction and broker notification are appropriate. Ignoring errors, blaming clients, or deleting records creates greater compliance risk. Professional practice requires correction and documentation. Question 3. A loan payment schedule gradually reduces principal until the loan balance reaches zero. What financing term describes this for Hayden and Egan involving a small retail building priced at $246,500? Option A. Accretion. Option B. Subordination. Option C. Amortization. Option D. Cheat. The correct answer is option C. Amortization. Amortization is repayment of a debt through payments that reduce principal over time. Accretion is natural land buildup. Subordination changes lien priority, and cheat transfers property to the state when no heirs exist. The decreasing loan balance is the clue. Question 4. In a dual agency situation in Brainerd, why must the licensee avoid advocating exclusively for one party? Option A. The broker becomes a government mediator. Option B. The buyer automatically becomes the broker's only client. Option C. The seller's broker relationship disappears at acceptance. Option D. The broker owes duties to both buyer and seller within the limits of dual agency. The correct answer is option D. The broker owes duties to both buyer and seller within the limits of dual agency. Dual agency means the broker owes duties to both sides and must work within those limits. The broker is not converted into a government mediator, and neither party becomes the only client. Acceptance of an offer does not eliminate the agency relationship or the disclosure limits. Question 5. A homestead classification question appears on a Minnesota practice exam. What topic is being tested most directly for Quinn in Duluth involving a farm parcel priced at $421,000? Option A. Property tax and ownership status treatment. Option B. Federal lead paint pamphlet rules only. Option C. Advertising font size only. Option D. Dual agency consent wording only. The correct answer is option A. Property tax and ownership status treatment. Homestead classification generally relates to property tax and ownership or occupancy status. Lead paint, advertising, and dual agency are separate real estate topics. Exam questions may connect homestead status with tax treatment and ownership rights. Question 6. A residential buyer has not signed a representation contract. How should the licensee describe the buyer's status after agency disclosure for Casey and Eden Prairie involving a condominium unit priced at $222,500? Option A. The buyer is automatically a client forever. Option B. The buyer is a customer unless and until a written representation contract is signed. Option C. The buyer becomes the broker's employee. Option D. The buyer receives ownership rights in the brokerage. The correct answer is option B. The buyer is a customer unless and until a written representation contract is signed. Minnesota agency disclosure explains that a consumer is not represented until a written representation contract is signed. Customer status is different from client representation. Employment and ownership rights are not created by receiving agency disclosure. Question 7. A neighbor receives permission to park on Finley Peterson's land for one weekend only. What interest is most likely created? Option A, easement appurtenant. Option B, fee simple estate. Option C, license. Option D, a mechanic's lien. The correct answer is option C, license. A license is personal permission to use property and is generally revocable. An easement appurtenant is a more durable interest tied to benefited land, fee simple is ownership, and a mechanic's lien secures payment. Temporary parking permission is a license. Question 8. If Quinn passes the salesperson examination on a spring test date, how long does the candidate generally have to apply for the license before retaking the exam is required? Option A, 30 days from passing the examination. Option B, 3 years from passing the examination. Option C, until the next broker renewal cycle only. Option D, 1 year from passing the examination. The correct answer is option D, 1 year from passing the examination. Minnesota guidance states that the salesperson license application must be made within 1 year after passing the examination. Shorter periods such as 30 days are too restrictive, and longer periods ignore the retake requirement. The broker renewal cycle does not control the candidate's examination validity period. Question 9. A buyer receives a qualified third-party inspection report, but the licensee knows a fact that contradicts it. What must the licensee do for Casey in Eden Prairie involving a condominium unit priced at $390,500? Option A, disclose known facts that contradict the report. Option B, stay silent because the report always controls. Option C, destroy the report and order a new one. Option D, tell only the inspector after closing. The correct answer is option A, disclose known facts that contradict the report. A licensee may rely on a qualified third-party report unless the licensee knows facts that contradict it. Known contradictions must be disclosed to the parties. Silence, destruction of the report, or delayed notice would undermine the disclosure duty. Question 10. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Drew in Edina involving a single-family home priced at $444,000? Option A, immediate ownership and possession of the property. Option B, a lien securing repayment while the borrower retains title. Option C, a life estate measured by the borrower's life. Option D, a leasehold estate for the loan term. The correct answer is option B, a lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 11. A salesperson tells owners in Rochester to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe? Option A, reconciliation. Option B, hypothecation. Option C, blockbusting. Option D, assemblage. The correct answer is option C, blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step, hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 12. Why might Druchin use a quitclaim deed to clear a possible title issue? Option A, it guarantees the property is free of every lien. Option B, it creates a new mortgage automatically. Option C, it replaces the need for delivery and acceptance. Option D, it transfers whatever interest the grantor may have without making title warranties. The correct answer is option D, it transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 13. After passing the examination, Reese wants to submit a Minnesota salesperson license application immediately. Which education requirement still must be met before applying for Reese in Mankato involving a single-family home priced at $335,000? Option A. Courses 2 and 3 must be successfully completed if they have not already been completed. Option B. Only Course I is ever required for the license. Option C. A broker's 30-hour course must replace Course 3. Option D. No additional education is needed once the exam is passed. The correct answer is option A. Courses 2 and 3 must be successfully completed if they have not already been completed. Course I opens exam eligibility, but courses 2 and 3 must be completed before the salesperson license application. Passing the exam does not erase the remaining pre-license education requirement. The other options either omit required courses or invent a broker-only replacement course. Question 14. A deed is signed by the grantor but never delivered to Jordan Nolan. Why is delivery important? Option A. Delivery sets the mortgage interest rate. Option B. Delivery shows the grantor's intent that the deed take effect. Option C. Delivery replaces legal description requirements. Option D. Delivery creates a leasehold only. The correct answer is option B. Delivery shows the grantor's intent that the deed take effect. A deed must be delivered and accepted to operate as a conveyance. Delivery reflects the grantor's intent that the instrument take effect. It does not set loan terms, replace the legal description, or create only a leasehold. Question 15. An advertisement says a condominium unit is available only for adults with no children. What is the main fair housing concern for Quinn in Duluth involving a condominium unit priced at $229,500? Option A. The ad forgot to mention the roof age. Option B. The ad uses a list price instead of an appraised value. Option C. The statement indicates a preference or limitation based on familial status. Option D. The ad includes the city name. The correct answer is option C. The statement indicates a preference or limitation based on familial status. Advertising cannot indicate a discriminatory preference or limitation based on familial status except where a valid housing for older persons exemption applies. Roof age, list price, and city name are not the fair housing issue in the wording. The problem is discouraging families with children. Question 16. A utility company has the right to run power lines across a Bemidji parcel. Which property right is usually involved? Option A. Estate for years. Option B. Divulsion. Option C. Remainder interest. Option D. Easement in gross. The correct answer is option D. Easement in gross. A utility easement often benefits a company rather than a neighboring parcel, making it an easement in gross. An estate for years is a leasehold, a avulsion is sudden land change, and a remainder follows a life estate. The utilities right is a non-possessory use right. Question 17. A Minnesota salesperson renewal fee includes a contribution to which fund for Reese in Mankato involving a mixed-use property priced at $434,000? Option A. Real Estate Education, Research and Recovery Fund. Option B. Federal Flood Insurance Reserve. Option C. County Recording Technology Fund only. Option D. Private MLS Scholarship Account. The correct answer is option A. Real Estate Education, Research and Recovery Fund. Minnesota salesperson license fees include an amount for the Real Estate Education, Research and Recovery Fund. Flood insurance reserves, county recording funds, and private MLS accounts are unrelated. The fund is part of the state licensing fee structure. Question 18. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Blair and Bemidji involving a vacant lot priced at $267,500? Option A. Cost approach only. Option B. Sales comparison approach. Option C. Income approach only. Option D. Front foot method only. The correct answer is option B. Sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 19. A parcel borders a non-navigable stream. Rights connected to that water are commonly called what for Emerson in Bloomington involving a farm parcel priced at $463,500? Option A, literal rights only. Option B, emblement rights. Option C, riparian rights. Option D is subrogation rights. The correct answer is option C, riparian rights. Riparian rights relate to land adjoining rivers or streams. Literal rights are associated with lakes and other large bodies of water, while emblements and subrogation are different concepts. Water-adjacent property rights are common ownership questions. Question 20. A landlord in St. Paul deducts from a security deposit for unpaid rent and damage beyond ordinary wear and tear. What makes those deductions more defensible for Avery in St. Paul involving a fourplex priced at $362,500? Option A. They are based only on the landlord's dislike of the tenant. Option B. They include normal fading of paint from ordinary use. Option C. They are taken without notice because deposits are always non-refundable. Option D. They are tied to permitted reasons and supported by a written explanation. The correct answer is option D. They are tied to permitted reasons and supported by a written explanation. Minnesota security deposit deductions are generally tied to unpaid obligations or damage beyond ordinary wear and tear, with a written explanation when money is withheld. Personal dislike, normal wear, and treating every deposit as non-refundable are not defensible bases. Documentation is essential in landlord-tenant accounting. Question 21. A legal description refers to township, range, and section. Which survey system is being used for Reese in Mankato involving a mixed-use property priced at $413,500? Option A, rectangular government survey system. Option B, meets and bounds only. Option C, lot and block only. Option D, a gross lease system. The correct answer is option A, rectangular government survey system. The rectangular government survey system uses townships, ranges, and sections. Meets and bounds relies on boundary calls, and lot and block relies on subdivision plats. Gross lease is a lease structure, not a land description system. Question 22. Which document is used to convey ownership of real property from grantor to grantee for Avery in St. Paul involving a fourplex priced at $237,000? Option A, promissory note. Option B, deed. Option C, listing presentation. Option D, home inspection checklist. The correct answer is option B, deed. A deed is the instrument used to convey title from grantor to grantee. A promissory note creates a debt promise, a listing presentation markets services, and an inspection checklist reports property condition. Conveyance and financing documents have different functions. Question 23. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Kendall and Brainerd involving a small retail building priced at $415,500? Option A. The state sets one mandatory commission rate for all residential listings. Option B. The MLS sets the minimum commission for every listing. Option C. Compensation is determined between each individual broker and the broker's client. Option D. The buyer must always pay the listing broker directly. The correct answer is option C. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 24. If annual property taxes of $2,750 are prorated to the seller for 178 days on a 365-day basis, approximately what amount is charged to the seller? Option A, $24,080. Option B, $7,224. Option C, $1,304. Option D, $1,341. The correct answer is option D, $1,341. Tax proration divides the annual tax by 365 and multiplies by the number of seller days. Commission, discount points, and monthly interest are unrelated calculations. Proration allocates an annual expense fairly between buyer and seller at closing. Question 25. A city takes private land for a public road after paying just compensation. What power is being exercised for Jordan and Red Wing involving a mixed-use property priced at $417,500? Option A, eminent domain. Option B, this cheat. Option C, the adverse possession. Option D, police power only. The correct answer is option A, eminent domain. Eminent domain is the government's power to take private property for public use with just compensation. Escheat transfers property to the state when no heirs exist, and adverse possession is private acquisition through possession. Police power regulates use but does not by itself describe a compensated taking. Question 26. A broker refuses to show listings unless a buyer also uses the broker's mortgage affiliate. What antitrust concept could be implicated for Reese in Mankato involving a lake cabin priced at $231,000? Option A, accretion. Option B, tie-in arrangement. Option C, estoppel. Option D, substitution principle. The correct answer is option B, tie-in arrangement. A tie-in arrangement conditions one service on the purchase of another service and can raise antitrust concerns. Accretion, estoppel, and substitution are property or valuation concepts. Consumers should not be unlawfully forced into affiliated services. Question 27. A $372,500 sale carries a 6.5% commission. What is the total commission before any split? Option A, $74,500. Option B, $4,470. Option C, $24,212. Option D, $3,576. The correct answer is option C, $24,212. Total commission is found by multiplying the sale price by the commission rate. Down payment, discount points, and property tax calculations use different bases. The phrase before any split means the full brokerage commission is calculated first. Question 28. If a broker provides the predatory offender registry notice in a timely manner, what is generally true about offender registry information for Casey and Eden Prairie involving a farm parcel priced at $396,000? Option A. The broker must personally investigate every nearby resident. Option B. The broker must guarantee no offenders live in the city. Option C. The broker must cancel the purchase agreement automatically. Option D. The broker has no duty to disclose specific registry information beyond the required notice. The correct answer is option D. The broker has no duty to disclose specific registry information beyond the required notice. Minnesota disclosure law limits a licensee's duty regarding registry information when the required notice is provided. The broker does not guarantee neighborhood conditions or act as law enforcement. Automatic contract cancellation is not the disclosure rule. Question 29. A lender draws a line around a Rice neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits? Option A, redlining. Option B, plottage. Option C, accretion. Option D, estoppel. The correct answer is option A, redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 30. A listing agreement for a Blaine seller is missing a definite end date. Why is that a licensing problem? Option A. Listing agreements are valid only if they renew forever. Option B. Minnesota listing agreements must include a definite expiration date. Option C. Expiration dates are allowed only in commercial leases. Option D. The county recorder assigns the expiration date after closing. The correct answer is option B. Minnesota listing agreements must include a definite expiration date. Minnesota listing agreements must be written and include a definite expiration date. Automatic indefinite listings create consumer protection concerns and do not meet the required content rules. County recorders do not supply listing agreement expiration dates. Question 31. A legal description identifies a lot and block in a recorded subdivision plat. Which description method is used for Harper in Maple Grove involving a fourplex priced at $226,500? Option A, rectangular survey only. Option B, monumentless description. Option C, lot and block. Option D, a front foot appraisal. The correct answer is option C, lot and block. Lot and block descriptions rely on a recorded subdivision plat. Rectangular survey uses sections, townships, and ranges, while front foot appraisal values frontage. The presence of a recorded plat points to lot and block. Question 32. A broker compares a buyer's desired use with zoning rules, parcel size, and market demand. What appraisal principle is being considered for Hayden and Egan involving a newly built townhouse priced at $392,500? Option A, tie-in arrangement. Option B, novation. Option C, steering. Option D, highest and best use. The correct answer is option D, highest and best use. Highest and best use evaluates legal permissibility, physical possibility, financial feasibility, and maximum productivity. Tie-in arrangements, novation, and steering involve antitrust, contract substitution, and fair housing concerns. The analysis is about the most supportable property use. Question 33. A buyer asks whether a nursing home in the neighborhood must be disclosed as a material fact. How does Minnesota treat the issue for Reese in Mankato involving a lake cabin priced at $278,500? Option A. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Option B. It is always a material defect in the property. Option C. It requires a separate appraisal license. Option D. It makes the deed void. The correct answer is option A. The location of a nursing home nearby is not a material fact that must be disclosed merely for that reason. Minnesota law excludes certain neighborhood-related facilities, including nursing homes, from material fact treatment merely because they are nearby. This does not remove duties to disclose physical defects or known material facts. Appraisal licensing and deed validity are unrelated. Question 34. A buyer representation agreement in Woodbury is best described as what type of document? Option A. A deed transferring title to the buyer. Option B. A written contract that creates agency representation for the buyer. Option C. A loan commitment from the lender. Option D. A property tax statement from the county. The correct answer is option B. A written contract that creates agency representation for the buyer. A buyer representation agreement is the written contract that creates buyer agency. It does not transfer title, approve financing, or state county taxes. Representation contracts define the broker-client relationship and compensation terms. Question 35. A rumor says a St. Paul home was once the site of a natural death and possible paranormal activity. Under Minnesota disclosure rules, how is that fact treated for Avery in St. Paul involving a duplex priced at $388,500? Option A. It must always be disclosed in the listing contract. Option B. It makes the property unmarketable until court approval. Option C. It is not treated as a material fact that must be disclosed merely for that reason. Option D. It requires the buyer to receive a separate environmental report. The correct answer is option C. It is not treated as a material fact that must be disclosed merely for that reason. Minnesota law states that certain stigmatizing facts, such as suicide, natural death, or perceived paranormal activity, are not material facts requiring disclosure merely because they occurred. That does not change the duty to disclose physical defects or other material facts. Listing contracts, court approval, and environmental reports address different issues. Question 36. A property owner dies with no will and no heirs. What government power may transfer the property to the state for Cameron in Moorhead involving a rental house priced at $302,000? Option A, eminent domain. Option B, literal rights. Option C, subordination. Option D, this cheat. The correct answer is option D, is cheat. Is cheat transfers property to the state when an owner dies without a will and without heirs. Eminent domain involves compensated taking. Literal rights involve water, and subordination changes lien priority. The absence of heirs is the clue. Question 37. In Mankato, a new applicant asks which combination best describes the salesperson licensing path in Minnesota. Option A. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Option B. Be at least 21, complete only course I, and work independently after passing the exam. Option C. Complete continuing education before any pre-license education and apply directly without a broker. Option D. Pass only the national exam and begin practicing while the application is pending. The correct answer is option A. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 38. Under the Minnesota Human Rights Act, which protected basis expands beyond the traditional federal fair housing list for Riley in Minneapolis involving a mixed-use property priced at $304,000? Option A, preference for a short commute. Option B, status with regard to public assistance. Option C, owning 2 vehicles. Option D, having a fixed-rate mortgage. The correct answer is option B, status with regard to public assistance. Minnesota housing and real property discrimination law includes status with regard to public assistance among protected bases. Commute preference, vehicle ownership, and mortgage type are not protected classes. State law can add protections beyond the federal baseline. Question 39. If Emerson fails to complete required continuing education by the renewal deadline, what license consequence can occur? Option A. The license automatically converts to a broker license. Option B. The license becomes a deed restriction. Option C. The license can become inactive. Option D. The license renews for free without further action. The correct answer is option C. The license can become inactive. Failure to complete continuing education before the deadline can cause a Minnesota real estate license to become inactive. It does not upgrade the license, affect title to property, or waive renewal obligations. Continuing education is a condition of maintaining active status. Question 40. If an override clause appears in Finley Cahn's listing agreement, what must the licensee provide within 72 hours after the listing expires for the clause to be effective? Option A. A new deed. Option B. A county tax appeal. Option C. A mortgage payoff statement. Option D. A protective list. The correct answer is option D. A protective list. An override clause is tied to a protective list supplied within the required time after expiration. A deed, tax appeal, or payoff statement does not preserve the broker's override rights. The protective list identifies prospects covered by the clause. Question 41. A city special assessment for a new sidewalk appears on a property record. What kind of charge is it most like for Taylor in Northfield involving a rental house priced at $220,000? Option A. A charge against benefited property for a public improvement. Option B. A private broker commission split. Option C. A personal credit card debt. Option D. A title insurance premium refund. The correct answer is option A. A charge against benefited property for a public improvement. A special assessment is commonly charged against properties that benefit from a public improvement. It is not a broker split, personal consumer debt, or title insurance refund. Assessments can affect closing and ownership costs. Question 42. When Taylor, a licensee, intends to buy a client's property in Northfield, what disclosure is required before negotiation or consummation? Option A. The licensee may stay silent if paying full market value. Option B. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. Option C. The disclosure is needed only after the deed is recorded. Option D. Only the buyer's lender must be told about the license. The correct answer is option B. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 43. Before Kendall schedules the salesperson examination after studying in Winona, which pre-license course must already be completed? Option A, Course 2 only. Option B, Course 3 only. Option C, Course I. Option D, the annual continuing education module. The correct answer is option C, Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 44. At closing, why are prepaid property taxes or rents commonly prorated between buyer and seller for Quinn in Duluth involving a condominium unit priced at $438,000? Option A. To change the sales price after acceptance. Option B. To avoid recording the deed. Option C. To eliminate the need for title insurance. Option D. To allocate income or expenses to the party who owned the property during the relevant time period. The correct answer is option D. To allocate income or expenses to the party who owned the property during the relevant time period. Prorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation. Question 45. During negotiations in Northfield, Avery Gwynn changes the price and closing date in the seller's offer. What is the legal effect of that response? Option A. It is a counteroffer that rejects the original offer and proposes new terms. Option B. It is an acceptance because some terms stayed the same. Option C. It creates a lease instead of a purchase contract. Option D. It keeps the original offer open forever. The correct answer is option A. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 46. During a first substantive contact with a residential consumer in Bloomington, what disclosure should the licensee provide for Emerson in Bloomington involving a vacant lot priced at $235,000? Option A. A final closing disclosure showing loan terms. Option B. An agency disclosure form explaining available agency and facilitator relationships. Option C. A county tax statement for the current year. Option D. A deed prepared for recording. The correct answer is option B. An agency disclosure form explaining available agency and facilitator relationships. Minnesota requires an agency disclosure form at the first substantive contact in residential transactions covered by the statute. The form explains representation choices and facilitator status before the consumer decides whether to enter a representation contract. Closing disclosures, tax statements, and deeds serve different functions later in the transaction. Question 47. A parcel borders a lake near Maple Grove. Rights associated with use of the lake shore are commonly called what? Option A, riparian rights only. Option B, fixture rights. Option C, littoral rights. Option D, novation rights. The correct answer is option C, littoral rights. Littoral rights generally relate to property bordering lakes, seas, or oceans. Riparian rights involve rivers and streams. Fixtures concern attached property, and novation is contract substitution. The lakefront fact drives the answer. Question 48. Which Minnesota tax is generally associated with recording a mortgage that secures debt on real property for Hayden and Egan involving a small retail building priced at $467,500? Option A, personal income withholding tax. Option B, sales tax on furniture. Option C, special assessment appeal fee. Option D, mortgage registry tax. The correct answer is option D, mortgage registry tax. Mortgage registry tax is tied to the recording of a mortgage securing debt. Personal income withholding, furniture sales tax, and assessment appeals are different issues. The exam often distinguishes mortgage registry tax from deed tax. Question 49. Why is the Minnesota agency disclosure form given to Drew Lee not enough by itself to create representation? Option A. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. Option B. It automatically creates dual agency for every transaction. Option C. It replaces all purchase agreement requirements. Option D. It gives the consumer a license to sell property. The correct answer is option A. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 50. A borrower signs a promissory note and mortgage to finance a Winona home. What does the note do? Option A. Transfers title to the lender at closing. Option B. Creates the borrower's personal promise to repay the debt. Option C. Sets the zoning classification. Option D. Records the deed tax payment. The correct answer is option B. Creates the borrower's personal promise to repay the debt. The promissory note is the borrower's promise to repay according to the loan terms. The mortgage secures that promise with a lien on the property. Zoning, title transfer, and deed tax are separate matters. Question 51. Two brokerages agree that one will work only north of Bloomington and the other only south. What antitrust violation may this suggest? Option A. Redemption. Option B. Assemblage. Option C. A market allocation. Option D. A subrogation. The correct answer is option C, market allocation. Market allocation occurs when competitors divide customers or territories instead of competing. Redemption, assemblage, and subrogation are unrelated real estate concepts. Geographic division by competing brokerages creates serious antitrust risk. Question 52. If a Eden Prairie property sells for $449,000 and the buyer obtains a 75% loan, what is the buyer's down payment? Option A, $336,750. Option B, $28,062. Option C, $852. Option D, $112,250. The correct answer is option D, $112,250. The down payment is the sale price minus the loan amount. The loan amount is the financed portion, the commission is a brokerage compensation calculation, and the tax proration allocates property taxes. Separating buyer equity from loan proceeds is a core exam math skill. Question 53. Why should a purchase agreement for a farm parcel in Bloomington be in writing and signed by the party to be charged? Option A. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option B. All oral contracts are criminal offenses. Option C. Only lenders may sign real estate contracts. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option A. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 54. A licensee in St. Paul drafts a complex legal clause for Sawyer Thompson instead of recommending legal counsel. What risk is created? Option A. Constructive eviction. Option B. Unauthorized practice of law. Option C. Functional obsolescence. Option D. Inverse condemnation. The correct answer is option B. Unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 55. Two investors own a Egan duplex with unequal shares and no survivorship language. Which ownership form is most likely for Hayden and Egan, involving a newly built townhouse priced at $452,500? Option A. Tenancy by the entirety. Option B. Severalty. Option C. Tenancy in common. Option D. Life tenancy only. The correct answer is option C. Tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life. Tenancy by the entirety is a special marital form not described by unequal investor shares. Question 56. A seller instructs the licensee not to disclose a known structural defect to buyers. Which principal controls for Skylar in Winona, involving a small retail building priced at $468,500? Option A. The licensee must obey every instruction from a client. Option B. The defect becomes confidential forever. Option C. The buyer's broker alone must discover every defect. Option D. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. The correct answer is option D. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Obedience applies only to lawful instructions. A client cannot require a licensee to hide a material fact that law requires to be disclosed. The duty to disclose known material defects is not shifted entirely to the buyer's broker. Question 57. Which deed gives Taylor Peterson the broadest set of title warranties from the grantor? Option A. General warranty deed. Option B. Quitclaim deed. Option C. Bargain and sale deed with no covenants. Option D. Tax certificate only. The correct answer is option A. General warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 58. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Emerson in Bloomington, involving a farm parcel priced at $255,500? Option A. It is always protected opinion regardless of knowledge. Option B. It is a factual misrepresentation about a material property condition. Option C. It is allowed if the buyer gets a loan. Option D. It becomes legal if stated verbally instead of in writing. The correct answer is option B. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 59. A licensee directs families with children only toward one area of Minneapolis. What fair housing problem does that conduct create? Option A, amortization. Option B, subordination. Option C, steering. Option D, novation. The correct answer is option C, steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 60. If one broker represents both Parker Thompson and Reese Kahn in a residential transaction, what must occur before the broker acts as a dual agent? Option A. Only the seller must consent because the seller listed the property. Option B. The broker may proceed without consent if the commission is reduced. Option C. Consent is unnecessary if two different salespersons are involved. Option D. All parties must give informed consent to the dual agency relationship. The correct answer is option D. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and two salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 61. Before negotiating a purchase involving a licensee's sibling as a principal, what should the licensee do for Cameron in Moorhead involving a fourplex priced at $306,000? Option A. Disclose the relationship in writing before negotiating or consummating the transaction. Option B. Say nothing because relatives are not licensees. Option C. Disclose only after the commission is paid. Option D. Ask the lender to disclose it instead. The correct answer is option A. Disclose the relationship in writing before negotiating or consummating the transaction. Minnesota requires written disclosure when a principal is a licensee's relative or business associate. Waiting until after commission payment is too late, and the duty is not shifted to the lender. The rule protects parties from undisclosed conflicts of interest. Question 62. A Harbor Realty branch office wants licensees to access current Minnesota statutes and rules electronically. Is electronic access acceptable? Option A. No, only a paper binder signed by every buyer is allowed. Option B. Yes, access to required statutes and rules may be made available electronically. Option C. Yes, but only if clients pay a records fee. Option D. No, statutes are never required in real estate offices. The correct answer is option B. Yes, access to required statutes and rules may be made available electronically. Minnesota standards allow access to required statutes and rules through an electronic agent. A paper-only rule, client fee requirement, or no access approach misstates the standard. The point is that licensees must have current legal resources available. Question 63. Why would an appraiser rely heavily on the cost approach for a newly built farm parcel in Stillwater? Option A. It ignores land value completely. Option B. It is the only legal method for all residential property. Option C. Replacement cost and depreciation can be estimated more reliably for new improvements. Option D. It values the property only by monthly rent. The correct answer is option C. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 64. Under Chapter 82 standards, what must a broker do to properly supervise salespersons at a St. Paul office? Option A. Let each salesperson approve their own contracts without broker review. Option B. Delegate all trust records to buyers and sellers. Option C. Supervise only advertising and ignore purchase agreements. Option D. Monitor brokerage activities, review transaction documents, and review trust account books and records. The correct answer is option D. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 65. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Skylar in Winona involving a townhome priced at $453,000? Option A. Reasonable accommodation. Option B. Adverse possession. Option C. Yield spread premium. Option D. Defeasance clause. The correct answer is option A. Reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 66. If Kendall Patel tells the licensee that the seller will not perform under the signed purchase agreement, what must the licensee do? Option A. Keep the information confidential until the closing date. Option B. Immediately disclose the stated intent not to perform to the other party or parties. Option C. Cancel the agreement without telling the buyer. Option D. Disclose only if the seller misses a loan contingency. The correct answer is option B. Immediately disclose the stated intent not to perform to the other party or parties. A licensee put on notice that a party will not perform according to the transaction agreement must disclose that intent to the other party or parties. Keeping the information secret would mislead the other side. The rule is different from a party's inability to satisfy a contingency. Question 67. A restaurant tenant installs removable ovens for the tenant's business. What are those items often called for Drew in a dina involving a mixed-use property priced at $342,500? Option A. Riparian rights. Option B. Deed restrictions. Option C. Trade fixtures. Option D. Remainders. The correct answer is option C. Trade fixtures. Trade fixtures are business-related items installed by a tenant and usually removable if removed timely and damage is repaired. Riparian rights concern water, deed restrictions limit property use, and remainders are future interests. The tenant's business equipment points to trade fixtures. Question 68. A zoning ordinance limits building height in Eden Prairie. What government power is most directly involved? Option A. Eminent domain. Option B. This cheat. Option C. Taxation only. Option D. Police power. The correct answer is option D. Police power. Police power allows government to regulate property use for health, safety, morals, and general welfare. Eminent domain is taking for public use, escheat handles ownerless property, and taxation raises revenue. Zoning is a classic police power regulation. Question 69. At Riverbend Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers for Hayden and Egan involving a townhome priced at $247,500. Option A. Pulse. Option B. MLS Grid. Option C. Torrens Online. Option D. HUD Exchange. The correct answer is option A. Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 70. In appraisal, what does highest and best use require for Reese in Mankato involving a single-family home priced at $408,500? Option A. The use that produces the highest commission. Option B. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Option C. The use preferred by the current tenant only. Option D. The use with the lowest property tax bill. The correct answer is option B. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 71. A Stillwater parcel contains 3 acres. How many square feet are in the parcel? Option A, $66,000. Option B, $374,000. Option C, $130,680. Option D, $5,610. The correct answer is option C, 130,680. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 72. What is the main purpose of an owner's title insurance policy for Kendall Okafor? Option A. To insure the roof against storm damage. Option B. To guarantee future market appreciation. Option C. To replace the need for a purchase agreement. Option D. To protect against covered title defects that existed before the policy date. The correct answer is option D. To protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 73. When Cameron Gwynn buys a condominium unit in St. Cloud, what does the buyer typically own? Option A. The individual unit plus an undivided interest in the common elements. Option B. Only a stock certificate and no real property interest. Option C. The entire building in severalty. Option D. A temporary license to occupy the unit. The correct answer is option A. The individual unit plus an undivided interest in the common elements. Condominium ownership generally includes the individual unit and an undivided interest in common elements. A cooperative usually involves shares and a proprietary lease, not condominium ownership. The buyer does not own the whole building alone or merely hold a temporary license. Question 74. Which Minnesota tax is generally associated with recording a deed that conveys real property for Finley and Stillwater involving a farm parcel priced at $257,500? Option A. Mortgage registry tax only. Option B. State deed tax. Option C. Utility franchise fee. Option D. Federal gift tax return fee. The correct answer is option B. State deed tax. Deed tax is generally associated with recording a deed conveying real property. Mortgage registry tax relates to mortgage debt, while utility franchise and federal gift tax issues are outside the ordinary deed recording charge. The transaction document determines which tax applies. Question 75. Which event usually allows trust funds in a Minnesota real estate transaction to be disbursed for Kendall and Brainerd involving a small retail building priced at $453,500? Option A. A verbal request from one salesperson. Option B. A social media announcement that the deal is done. Option C. Closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Option D. The buyers hope to renegotiate after closing. The correct answer is option C. Closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Trust funds may be disbursed only under recognized authority such as closing, written agreement, applicable statutory affidavit, or court order. A verbal request or social media post does not provide the necessary authority. A buyer's later wish to renegotiate is not a trust fund disbursement event. Question 76. A deed gives Cameron possession for life, then ownership passes to Cameron Gwynn. What interest does Cameron Gwynn hold before Cameron's death? Option A. Leasehold estate. Option B. Easement in gross. Option C. Mortgage lien. Option D. A remainder interest. The correct answer is option D, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 77. A sudden flood removes soil from a riverbank in Dakota County. What term describes the sudden loss? Option A, avulsion. Option B, accretion. Option C, assemblage. Option D, plottage. The correct answer is option A, avulsion. Avulsion is sudden loss or change of land by natural forces. Accretion is gradual buildup, assemblage combines parcels, and plottage is the value increase from assemblage. The word sudden distinguishes avulsion. Question 78. A buyer includes an inspection condition in a Duluth purchase agreement. What is the role of that contingency? Option A. It automatically transfers title to the buyer. Option B. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. Option C. It eliminates the need for earnest money accounting. Option D. It makes the broker a home inspector. The correct answer is option B. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 79. A rental property produces $57,000 in net operating income and investors require a 6% capitalization rate. What value is indicated by the income approach? Option A, $247,500. Option B, $174,750. Option C, $950,000. Option D, $11,200. The correct answer is option C, $950,000. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 80. If assessed value is $205,200 and the tax rate is 25 mils, what is the annual property tax? Option A, $1,272. Option B, $4,360. Option C, $38,475. Option D, $5,130. The correct answer is option D, $5,130. A mil is $1 per $1,000 of assessed value, so the tax is assessed value multiplied by mils divided by 1,000. Monthly interest, points, and down payment are financing calculations. Millage questions require converting mils to a decimal rate. Question 81. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Casey and Eden Prairie involving a farm parcel priced at $440,000? Option A. Within 3 business days of receipt or final acceptance, whichever is later. Option B. Only after the buyer's loan is fully underwritten. Option C. At any time before the deed is recorded. Option D. Within 30 calendar days after the first showing. The correct answer is option A. Within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 82. While interviewing with 2 firms in Stillwater, Casey asks how many Minnesota brokers may supervise the salesperson during the same period. Option A. 2 brokers if both brokers consent. Option B. 1 actively licensed broker. Option C. Any number of brokers if the salesperson discloses the arrangement. Option D. 1 broker for residential sales and a separate broker for leases. The correct answer is option B, one actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of one broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 83. Under Minnesota law, which statute is the primary source for real estate broker and salesperson regulation for Emerson in Bloomington involving a farm parcel priced at $240,000? Option A, Minnesota Statutes Chapter 287 only. Option B, the Federal Internal Revenue Code only. Option C, Minnesota Statutes Chapter 82. Option D, a local MLS policy manual only. The correct answer is option C, Minnesota Statutes Chapter 82. Chapter 82 governs real estate brokers and salespersons in Minnesota. Chapter 287 covers deed tax and mortgage registry tax topics, and federal tax law or MLS policies do not replace state licensing law. Exam questions often test which authority controls licensing conduct. Question 84. A social media ad for a fourplex in St. Paul uses a team name. What must the advertisement clearly and conspicuously display? Option A, only the salesperson's nickname. Option B, only the property street address. Option C, only the team logo without the brokerage. Option D, the real estate brokerage name. The correct answer is option D, the real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 85. If a seller rejects Sawyer Rivera's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A, no later than the next business day after rejection. Option B, only after the seller signs a different purchase agreement. Option C, at the end of the listing period. Option D, after the broker deducts marketing expenses. The correct answer is option A, no later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 86. A Rochester salesperson wants to place personal money in the broker trust account to save for taxes. Why is that improper? Option A, personal funds must always be kept in the listing broker's trust account. Option B, trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Option C, salespersons may use trust accounts as savings accounts with broker consent. Option D, commingling is allowed when the amount is less than 1 month's rent. The correct answer is option B. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Trust accounts are for trust funds, with only limited identified personal funds allowed for service charges or minimum balance requirements. Using the account as a personal savings account would commingle funds. Broker consent or a small amount does not change the commingling rule. Question 87. A zoning board permits a property use that otherwise violates strict zoning because of unique hardship. What relief is typically granted for Avery in St. Paul involving a duplex priced at $239,000? Option A, certificate of title. Option B, quitclaim covenant. Option C, variance. Option D, mortgage assumption. The correct answer is option C, variance. A variance provides relief from strict zoning requirements when legal standards are met, often involving unique hardship. Certificates of title, quitclaim deeds, and mortgage assumptions do not authorize zoning deviations. Land use approval is the issue. Question 88. A lender offers Jordan Nolan a mortgage whose interest rate can change based on an index after an initial period. What type of loan is this? Option A, package mortgage only. Option B, open-end listing. Option C, graduated lease. Option D, adjustable rate mortgage. The correct answer is option D, adjustable rate mortgage. An adjustable rate mortgage has an interest rate that may change according to an index and loan terms. A package mortgage includes personal property, an open-end listing is not a standard listing type, and a graduated lease changes rent over time. The index-based interest change identifies the loan type. Question 89. Which fiduciary duty requires a broker to follow a client's lawful directions for Parker and Rochester involving a townhome priced at $456,000? Option A, obedience. Option B, this cheat. Option C, novation. Option D, subordination. The correct answer is option A, obedience. Obedience requires following lawful client instructions. It does not require obeying illegal instructions or ignoring disclosure duties. Is cheat, novation, and subordination are unrelated legal concepts. Question 90. A Edina salesperson asks whether Minnesota state law or a private study guide controls if they conflict. Which source governs? Option A. The private study guide controls if newer. Option B. Minnesota law governs the licensing issue. Option C. A salesperson's office custom controls. Option D. The buyer's preferred answer controls. The correct answer is option B. Minnesota law governs the licensing issue. Official guidance makes clear that Minnesota law governs licensing issues. Study guides and office customs are learning tools or business practices, not controlling law. A buyer's preference cannot override statutory requirements. Question 91. A built-in dishwasher is attached and adapted to a small retail building. What is it most likely considered in a sale? Option A, emblement. Option B, trade name. Option C, fixture. Option D, license. The correct answer is option C, fixture. A fixture is personal property that has become real property through attachment, adaptation, intent, or agreement. Emblements are crops, a trade name is business identity, and a license is permission. Built-in appliances are commonly analyzed as fixtures. Question 92. A property use existed legally before a zoning change and may continue despite the new rule. What is it called for Hayden and Egan involving a small retail building priced at $402,000? Option A, blockbusting. Option B, estoppel certificate. Option C, defeasible fee only. Option D, illegal non-conforming use. The correct answer is option D, legal non-conforming use. A legal non-conforming use lawfully existed before a zoning change and is often allowed to continue under limits. Blockbusting is a fair housing violation, estoppel certificates relate to leases or representations, and defeasible fee is an ownership estate. The timing before the zoning change is key. Question 93. Recording a deed for a townhome in Crow Wing County primarily gives what type of notice to the public? Option A, constructive notice. Option B, private notice only to the buyer's lender. Option C, a zoning variance. Option D, a guarantee of physical condition. The correct answer is option A, constructive notice. Recording places an instrument in the public records and gives constructive notice of the recorded interest. It does not create a zoning variance or guarantee the property's physical condition. The public records system protects priority and notice, not building quality. Question 94. A legal description begins at a point of beginning and follows distances and directions around the boundary. Which system is used for Kendall and Brainerd involving a small retail building priced at $446,500? Option A, gross rent multiplier. Option B, meets and bounds. Option C, capitalization rate. Option D, straight line depreciation. The correct answer is option B, meets and bounds. Meets and bounds descriptions trace boundaries using distances, directions, and a point of beginning. GRM, cap rate, and depreciation are valuation concepts. The boundary walking format identifies the legal description method. Question 95. A facilitator working with Avery in Northfield performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A, loyalty to the seller only. Option B, obedience to the buyer's investment goals. Option C, confidentiality. Option D, advocacy for the party paying the commission. The correct answer is option C, confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 96. A Blaine buyer's loan has small monthly payments but one large final payment. What is that final payment called? Option A, proration credit. Option B, replacement reserve. Option C, equity dividend. Option D, a balloon payment. The correct answer is option D, balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing, a replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 97. Gradual soil buildup along a stream increases a parcel's size. What term best fits for Hayden and Egan involving a small retail building priced at $387,500? Option A, accretion. Option B, divulsion. Option C, condemnation. Option D, defeasance. The correct answer is option A, accretion. Accretion is gradual addition of land through natural forces. Avulsion is sudden change, condemnation is taking by eminent domain, and defeasance concerns loan satisfaction. Gradual buildup is the key clue. Question 98. A title search finds an unpaid mechanics lien recorded against a Red Wing property. Why does this matter to a buyer for Jordan and Red Wing involving a mixed-use property priced at $453,500? Option A. It proves the buyer has already paid cash. Option B. It may be an encumbrance affecting title and closing requirements. Option C. It automatically creates a condominium. Option D. It removes all property taxes. The correct answer is option B. It may be an encumbrance affecting title and closing requirements. A mechanics lien can encumber title and may need to be resolved before or at closing. It does not prove cash payment, create condominium ownership, or remove tax obligations. Title review identifies recorded claims that may affect ownership. Question 99. For Finley Garcia's first real estate job in Bemidji, who submits the Minnesota salesperson license application after the applicant becomes associated with a broker? Option A. The applicant directly through a personal account only. Option B. The listing client from the applicant's first transaction. Option C. The licensed real estate broker with whom the applicant is associated. Option D. The county recorder in the county where the applicant lives. The correct answer is option C. The licensed real estate broker with whom the applicant is associated. A Minnesota salesperson must be associated with a licensed broker, and the broker submits the license application. The applicant alone does not file the salesperson application, clients have no filing role, and county recorders do not issue salesperson licenses. Broker sponsorship is central to salesperson licensure. Question 100. A lot has 90 front feet worth $140 per front foot. What is the indicated front foot value? Option A, $1,982. Option B, $16,835. Option C, $535,714. Option D, $12,600. The correct answer is option D, $12,600. Front foot valuation multiplies frontage by the price per front foot. Tax proration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage.